Hello and welcome to a short piece about the new ACAS Code guidance on settlements, which has been issued on the 29th of July 2013. It deals with settlement agreements and discussions surrounding them, which are said to be confidential, and the exclusion of evidence concerning these from subsequent unfair dismissal claims. Section 111A of the Employment Rights Act 1996 provides for settlement agreements. In fact, compromise agreements, which is what they used to be called, now become settlement agreements. It introduces an extended form of confidentiality which goes beyond the principle of without prejudice negotiations, and which applies even where no dispute exists. And ACAS have now given guidance on confidentiality. So section 111A provides as follows, and this is the principle: evidence of pre-termination negotiations is inadmissible in any proceedings on a complaint of unfair dismissal. So pre-termination negotiations means any offer made or discussions held before the termination of the employment with a view to the employment being terminated on terms agreed between the employer and the employee. We'll note certain features about that. An offer has to be made, or there have to be discussions held, and they need to be with a view. And what do all of those concepts mean? Well, we'll be unpacking that as we go along. The principle doesn't apply where, according to the complainant's case, the circumstances are such that the legislation, be it the Employment Rights Act or some other provision, requires the complainant to be regarded as unfairly dismissed. Next, the tribunal has the power to disapply the principle to the extent that it considers just in relation to anything said or done which in its opinion was improper or which was connected with improper behaviour. So in other words, they can disapply the exclusion of the evidence, so the evidence will now be admissible if they feel that there has been improper behaviour or something connected with improper behaviour, and then the principle is disapplied to the extent that they think is just. The exclusion principle doesn't preclude evidence relating to an offer which is made without prejudice save as to costs in relation to the question of costs or expenses. A settlement agreement, according to the guidance, is a contract ending the employment on agreed terms under which the employee waives rights to make the particular legal claims covered by the agreement. So the provisions that apply to compromise agreements apply clearly to settlement agreements. Therefore, the agreement must state that the statutory conditions regulating settlement agreements are fulfilled. So, the agreement must be in writing, it must relate to a particular complaint or proceedings, so therefore you can't have full and final settlement of all claims type agreements. The employee must have been advised by an independent legal advisor on the terms and effect of the proposal, and on the effect that it has on the employee's ability to pursue the complaint. There must be an independent advisor. The independent advisor must have a current contract of insurance or professional indemnity covering the risk of a claim by the employee in respect of loss from the advice. And the independent advisor needs to be identified in the agreement. And those provisions as well need to be spelled out in writing. Now, the new principle relates to settlement agreement discussions. So confidentiality can apply even if there's no dispute, but also even if one party is unaware that there's a problem. However, ACAS go on to say that the effect of section 111A is that an offer can be made on a confidential basis, and that's in paragraph 6. If it is made on a confidential basis, then the discussions and the offer becomes evidentially inadmissible in the employment tribunal proceedings. If, on the other hand, there's already a dispute, then the offer can be made on a without prejudice basis, and that will need to be stipulated in the offer, clearly. However, it's clear that ACAS is interpreting the legislation, because pre-termination negotiations in the legislation means any offer made before the termination of employment in question, with a view to it being terminated on terms agreed between the employer and employee. ACAS appears to suggest that this means that the offer must be made on a confidential basis. So therefore, the employee who makes an offer but doesn't make it clear that it's on a confidential basis arguably is not covered by the exclusory rule, because there is no room on ACAS's guidance for an unexpressed intention that the matter is to be confidential. Having said that, of course, in ordinary contract terms, it is likely that the tribunals would support ACAS's approach, because the offer has to be made and the basis of the offer will need to be spelled out in most contractual situations. The principle doesn't apply in situations where there would be an automatically unfair dismissal. So, without prejudice discussions can be excluded if they're properly without prejudice, but evidence of the confidential discussions is admissible. The types of claims we're talking about are whistleblowers claims, union membership claims, and assertion of statutory rights. The exclusion principle doesn't apply in discrimination, harassment, and Equality Act 2010 victimisation or other unlawful act cases. So in those cases, the evidence of the discussions is just going to be admissible. I wanted to say something about the principle that there should be no improper behaviour, and if there is improper behaviour, a different rule applies. If there's improper behaviour, evidence will be excluded only to the extent that the employment tribunal thinks just. And ACAS points out that discriminatory behaviour, plainly, is improper. I'd add to that that of course it may also be actionable. Next, the principle of without prejudice is discussed by ACAS, and they make the point that it won't apply if there's fraud, undue influence, or some other unambiguous impropriety. So, for example, perjury or blackmail. ACAS says that the analogous principles apply to settlement discussions, which have been made on a confidential basis. ACAS makes the point that it's up to the tribunal to decide what improper behaviour is, but prays in aid the analogy with the things that remove the protection from without prejudice discussions. So, improper behaviour will include unambiguous impropriety, and it will also include harassment of all forms, bullying, intimidation, and these have been used in a sense that's broader than the technical senses used for harassment in the Equality Act 2010. It includes any behaviour that's naturally described as harassment, bullying or intimidation. It would include aggressive words or behaviour, obviously physical assault, the threat of assault or other criminal behaviour, victimisation of all sorts, and ACAS refers to discrimination because of the Equality Act 2010 protected characteristics, clearly it would include direct discrimination. It's less clear whether it would include indirect discrimination, but in certain circumstances there would be scope for it to do so. Improper behaviour also includes undue pressure, and ACAS goes into a bit of detail on this. Not giving reasonable time for consideration is included as undue pressure, and we'll see later on what's thought to be a reasonable time for consideration. Undue pressure would include, before any form of disciplinary action has started, telling the employee that if a settlement proposal is rejected, then dismissal will follow, and similarly an employee can't threaten to undermine the employer's public reputation. ACAS says that there's a specific exception to that if the whistleblowing provisions apply, and the scope of that exception to the exception will need to be explored. ACAS makes the point that the categories of improper behaviour are not closed, so that other improper behaviour can be found. I now move away from the ACAS Code itself to add some comments on improper behaviour. Clearly duress constitutes improper behaviour. However, I take the view that economic duress probably would not, and I'm thinking about the type of economic duress that was exhibited or argued over rather in Hennessy and Craigmile. In principle, of course, if economic duress is capable of rendering a contract voidable, it can render an employment contract voidable. However, I take the view that the circumstances in which it's likely to be successfully alleged will be exceptional in employment cases, and in any event they'll almost certainly constitute improper behaviour themselves. And the consequence of that, of course, is that if in those exceptional circumstances that it was necessary to talk about the negotiations, that would be possible. Improper behaviour is less than duress. In the case of duress, the influence must be such that the will of the person is overborne. In other words, the consent must have been vitiated by there being no real alternative available. However, even in that situation where there's a very clear alternative, namely to complain to an employment tribunal and to draw social security meanwhile, economic duress probably would not constitute a sufficient ground to vitiate the contract, and certainly would not, in my view, constitute improper behaviour. Even if there's sufficient economic duress to vitiate the contract, but the employer doesn't know about it, there is a question as to whether or not the employer's behaviour is improper behaviour. So in other words, it's necessary to see that the employer is aware of the pressure that's being placed on the employee. Misrepresentation by one party is capable of constituting improper behaviour, but it depends on whether or not the conduct is fraudulent or not. Mistakes by themselves, although they may be capable of voiding the contract, will not, in my view, be capable of constituting improper behaviour. Turning back again to the ACAS Code, once improper behaviour is found, the Employment Tribunal determines the extent of inadmissibility, and it will look at the extent to which it's just to exclude the discussions and so forth. Without prejudice discussions can, however, be excluded. The Code doesn't appear to be saying that improper behaviour and unambiguous impropriety are the same things. The ACAS Code also deals with how to reach a settlement agreement. Whoever wishes to make the proposal starts off and should make the proposal. ACAS says that it is helpful if reasons for the proposal are given. That may be the case sometimes. However, the Code goes on to say that the parties should be given a reasonable time to consider the proposed settlement agreement, and what will constitute a reasonable time will vary according to the circumstances. However, they set down the general rule that a minimum of 10 calendar days should be taken in order that the party can consider the written terms of a settlement agreement and for an employee to receive independent advice. ACAS makes it clear, however, that it's possible for the parties to agree otherwise. ACAS goes on to say that if there's a face-to-face meeting, the employer should let the employee be accompanied by a colleague or trade union official or representative. Finally, it says that all details of any payments due and the timings should be recorded in the agreement. The final point that needs to be made is that even if the settlement agreement is rejected, provided there's no improper behaviour, the parties cannot rely on the offer of the settlement